Hello, everyone. Welcome to Court with Krissy. After being charged with his third drunk driving, this bartender has some bad blood, and it's not with the Kansas City Chiefs. I hope you like it. Court with Krissy is now in session.
We are just waiting for our court reporter to log in. Allison, can you hear me? Allison, can you hear me?
I can hear you, Your Honor.
Excellent.
Can you hear me?
Yes, I can.
Perfect.
All right, thank you. Before I go on the record, Ms. Fabian, I understand you're under the weather, but I'm not sure it's an illness. I don't know if you've consumed any alcohol. I don't want you to, it's not illegal. You're not on bond. It's not illegal to come even to the courthouse drunk unless you make a scene or do something like that. However, I was supposed to take an OWI third plea and sentencing here today, and I'm just going to give you a little warning for the next time. I'm going to be easy on you today because I'm going to guess you've had anxiety or you're having a little bit of apprehension for today's hearing. I'm going to guess that may have led you to have some dinner or lunch and maybe a drink or two or whatnot. I don't know. But when I set this for the next date and time, you must be 100% sober, not one influencing intoxicant, either alcohol, drugs, or medications, unless they're taken as prescribed when I take your plea, okay? It's very important. And if you get, this is an OWI third, so I understand the anxiety and the apprehension that you're feeling and the angst and all of those emotions. But if we move forward at the next hearing, and then you have had any alcohol at all, because they test upstairs and they test in the jail when you go to report, it messes everything up and we have to redo everything. And that's going to waste more time of your attorney, more time of the court, and your time, quite honestly. All right. And so I understand, I get it. I don't know personally what you're feeling here today, but are we on the same page with the next hearing?
Yes.
All right. So I need your assurances that if I'm lenient on you here today, that at the next hearing, you're going to come prepared and you're going to come completely sober and you're going to be ready to accept the consequences.
Yes.
Okay. All right. We will go on the record in the matter 24 CT 39 24 TR 280 State of Wisconsin versus Eileen Fabian. The state appears through District Attorney James Renicky in person. Ms. Fabian appears in person with counsel Joel Schlitz. We're set here today in this matter for a plea and sentencing hearing. Off the record, Attorney Schlitz did ask the court if it would accommodate a request for an adjournment to another date and time to give Ms. Fabian a little bit more time to come to terms with the plea and sentencing and accepting the responsibility. The court has graciously granted that request, and we will reset the matter for another date and time. Mr. Schlitz, I know you don't practice a lot in this county, or you haven't in the recent past, but are there days and times when you know you're going to be in this area?
Next Friday.
Next Friday.
With you, Your Honor.
Oh, all righty then.
At, I believe, 11 a.m. Trittlewitz.
That's right. You're on the Trittlewitz matter. Looking forward to that. Why don't we do right before that hearing? I can set you for probably 10:30.
Okay.
All right.
Okay. Thank you, Your Honor.
And refresh my recollection. I believe that she was doing an IDIP equivalent course.
That's correct, Your Honor.
And
She's
did-
already done over 100 hours of community service. and
Excellent.
AOD
So-
And all those things.
She would be asking, and you'd be petitioning the court to do any type of jail time after the 48 consecutive hours by electronic monitor.
Yes,
that
and that's
correct?
all been arranged with Ms. Anderson, Your
All
Honor.
been set. And so what I'm going to ask Mr. Schlitz is if you just update Miss Anderson, let her know that it's moved to next Friday. And then we will go from there.
Thank you, Your Honor. I will do that.
All right, anything else that we need to address on the record today?
I was tempted to ask for a signature bond, but at this point, I guess I'll just leave it at that.
I'm just gonna guess that other than perhaps other OWIs, she doesn't have any other criminal convictions.
Not that I'm aware of, Your Honor.
So I'm gonna guess that today was out of character and that it's just due to anxiety. That right, Miss Fabian?
Yes.
All right. So I will leave you I won't enter a bond. You won't face any kind of bail jumps because I'm going to take you at your word that this was just a hiccup. And that you understand what's going to happen and you understand what's expected for next week, okay?
Yes.
All right. Then we are adjourned.
Thank you, Your Honor.
Thank you.
You're welcome.
We will go on the record in the matter 23 TR 1002 24 CT 01, State of Wisconsin versus Joshua Davis. The state appears through District Attorney James Renicky in person. Mr. Davis appears in person with counsel Daniel Chapman. We're here for a plea and sentencing because it's set for a plea and sentencing, and I have noticed you've done all you needed to do with the IDIP program, so that's good and that's positive. But I've been informed that this may or may not proceed as a plea today. Mr. Chapman, do you want me to turn it over to Mr. Davis?
I will just say that I am not prepared to do a plea today. If Mr. Davis would like to speak, I am going to advise him not to talk about the facts of the case, but if he wants to, that's up to him.
All right, Mr. Davis, you've heard the warning from Mr. Chapman because anything that you say in here can be used against you. And that any offer or any deal that's been extended could be retracted or taken away. But so you have that warning, and I'm not going to say you seem a little hot. Something's bothering you today. I'm just going to ask that when you can say your piece, you can say what you need to say, but just please be so respectfully.
I will try to be very eloquent
Okay.
and elegant.
Okay.
I am accepting this plea. Let's get that clear right now. But I want it on record that I am actually accepting this plea under a little bit of a personal whatever.
Personal, like you have angst about.
I have a little bit of angst about it, yes. And I need to just, I'm going to get into some specifics because I haven't been allowed to speak and well, we've been going on with this for what, 9-10 months now at this point in juncture. That December 3rd, everybody in town, everybody knows that I open the Pheasant Inn every Saturday and Sunday. I am there at 10 a.m. That Sunday, the Packers played the Chiefs. I was there at 10 a.m. I had the bar open at 11 a.m. I do not drink behind the bar. And I want to be very clear that my character and my integrity is actually the most important thing I have. I got done at 6 o'clock. Our bartender that followed up that nobody's called. Nobody's called to speak to the bartender who actually served me in that bar that night. Knows very clearly exactly what I drank and did not drink. I was there from 6 o'clock to 9:30, just after halftime of the Kansas City Chief game, merely because the owners of the bar were at the game and had requested that I stay there and help the new bartender with the extracurricular things we do during football games. I stayed until 9:30. I went home. I was making a taco casserole. I forgot my glasses and my stuff in a Crown Royal bag behind the bar. I went back to the bar to get my glasses. The incident happens. I'm not gonna go one way direction or the other on this whole thing. But at this point in juncture, it's 10:15 at night. So I've been in that bar from 6 to 10:15 at night on very minimal alcohol drinking, which is not being brought up because everybody's arguing a case based on police cameras. Look, we have one thing in common in this building. I've taken enough justice studies. I don't have my JD, but I was coming close to finishing my justice studies degree. We all have learned it's not what you know, it's what you can prove. We had cameras, brand new camera system put into the Pheasant Inn. That was right after that huge electrical storm that knocked out all our TVs and all our old cameras. I had requested Chris Peterson, the owner of the building, to monitor those cameras and pull up the film from the time that I walked into that bar to the time that I left that bar. He unfortunately didn't know how to operate the camera system, so he couldn't figure out how to put it onto a USB. So then I requested of the secondary owner to do the same thing. But I'm gonna be eloquent. He didn't get around to it until it was 4 hours too late to pull the film because it started to rewrite.
Yes.
So now I have no proof of exactly what I actually drank in the bar, regardless of what was said in front of the officer on his body cam. It doesn't really matter what I say on the body cam. It's what I can physically prove. And that was my proof. My proof was right there. The bartender has been adamant from day one, which I've told people exactly what she served me. Now, I don't know about this industry, but I do know about the bartending industry. We don't remember names, but we remember what you drank and we remember how much you drank. That's just the way that industry goes. So my physical proof to prove that 0.152 is an impossible blood test is impossible. By the time they tested me, it was 11 o'clock at night. 5 hours later, based on what I know for a fact I drank, there's no possible way I could be a 0.152, even if I hadn't eaten since 10 a.m. that morning. I did not drink at home. I was not a drinker previous to this, not a predominant one by any stretch of the imagination. Certainly haven't been one after. There's just no way. The only reason that I am accepting this plea is I do not have the personal finances to fight this blood test. Now, I talked to Pat Stengel down in Madison. He's not a friend of mine, but he's an acquaintance of a friend of mine. And I went through all this stuff with him. Pat Stengel was very clear with me that mistakes happen from the point they take the blood. I have no idea what happened to my blood from the point I walked out of that room. I have no idea how long it sat on a counter. I have no idea how long it took for him to put it back into a cooler. I don't know how long it took for him to get it down to Madison, how it got down to Madison. I don't know what happened to it when it sat in Madison. But I know, based on what I personally know, and I have a bartender that knows for a fact, and I have a bar owner who saw the film that knows for a fact what I drank. I do not drink at home. I certainly couldn't have drank enough in 45 minutes, or not even 45 minutes, while making a taco casserole, which, by the way, because of this incident, burned in my house, and it took a week to get that smell out of there. There's no way. There's no possible way I could be a 0.152. Period. It's impossible. I am a 210-pound, 6'1.5" person. There's no way. There's no way. Now, the bartender on that day was very clear that she served me 3 Coors Banquets and 2 Blackberry Brandy shots, of which I left half a Coors Banquet sitting on the edge of the bar with a tip. Chris Peterson watched the film, same thing. But because I do not have that film, I cannot prove, and I have the film for my house. My whole house is wired up with cameras. I wasn't drinking at home. So how I could, from 6 o'clock at night when I got done with my shift to 11 or 11:10 when they finally took my blood, have a 0.152 is above and beyond. That's like technically not possible. It's not physically possible. It's not biologically possible. I am going to accept this plea because I have much bigger things in my life that I need to deal with. I build compensated communities when I'm not a bartender. I have people that rely on me. I will go sit in jail. but I wanted it on record that I'm accepting this plea because I can't technically prove my innocence. But our bartender, the bartender with the server, she just walked out of the building. To this day, nobody's ever even called the bartender and asked her. You just merely just asked her, what did you serve them that night? So here I am accepting something based basically on body cams. Look, I'll be the first one to tell you, and I'm just an honest human being. I'm not a big fan of our police. Why am I not a big fan of our police? Because my what do they call that? My living relies on the police not hanging around my bar all night long. And I've watched my living since November of last year go from here down to here because nobody wants to come into town anymore. So at the time that I got pulled over in December with them, you know what? Here's the thing. They couldn't give me a speed limit. They said I was in prudent speed. There wasn't anybody in town. I live over behind the ball field. Everybody knows that goes from a 40 down to a 30 very quickly right there. Perhaps I was slightly over. I don't know. Nobody can tell me. Then they make a big scene in the report, like they had to burn carbon to catch up to me. The two officers were sitting in the community bank chitty-chatting with each other, which is what they always do. I was going, it's exactly 0.2 miles from the community bank where they're sitting to the Pheasant Inn parking lot. I don't think anybody had to burn carbon to catch up to me. As a matter of fact, I was parked in the parking lot of the Pheasant Inn and out of my car, I think, or at least getting out of my car when they pulled in the wrong way into the side parking lot and then turned their lights on. So the whole idea that I was flying through town at 75 miles an hour at some huge imprudent speed is a little bit, just to, in my opinion, a little bit ridiculous. Doesn't have to be their opinions, whatever. We can't prove that either. But I can prove, I know for a fact what I drank because I was not a drinker. Everybody who's known me for the last 2 years knows that I basically, this is what it came down to, Your Honor. I decided 2.5 years ago when I did drive home, ripped, that if the only way I could have friends or a relationship in this county was to drink or be at the bars, I was done. I don't hang out at bars. I do not go to bars except when I'm working, and when I'm done working, everybody there knows that I pack my stuff up and I leave. I don't take my free drink. I don't take nothing. I got a car full of like 50 bar chips for the Pheasant Inn alone because I don't drink. So I will accept this plea regardless of what he says, and I will accept whatever you put. I just want it on record that I am not in full agreement based on my integrity and my character and knowing darn well that I was not drunk that night and there's no way I could have a .152. And I have mentioned that and argued that from the day this has came up. I do not want to put anybody in a position where you look at them and say, okay, well, somebody's not doing something. I'm not here to do that either. I'm just here to clearly state something that I've been trying to state for 9 months. And nobody is listening. So that was it. I will accept the plea. I paid the money. I did 80 plus hours of community service. I tried to do a little extra not to have to go sit in jail for 2 days because, to be honest with each other, I am a productive member of this community, working with a lot of members of this community, trying to help a lot of members of this community. I have been a very responsible bartender my whole career here. I've never had any problems as a bartender, ever. You don't have the police called when I'm bartending. You don't have underage people coming when I'm bartending. Me sitting in jail for 2 days to be an unproductive human being is just, I don't know. It's just, if that's some liberal thing that the Madison people came up with, fine, so be it. But it's just ridiculous. But I'm going to tell you, all I guess I want to clarify is there's no way, possible way I could be a .152 when that blood test was taken. So that was it. But I will accept this plea regardless of what he has to say.
Thank you, Mr. Davis. That was a lot, and it's a lot to sink in and to hear. And I can definitely hear from what you went through and what you've been through and knowing yourself that I can't say anything, but I'm in this chair. I have to follow the law. I have to enforce the law, and I have to rely upon science.
Mhm.
And the only way I get to hear anything, and anyone gets to hear anything about the cases, is through the jury trial, in which the lab analysts will go over step by step, and the officers will go over step by step of when the blood was taken, how it was packaged, how it was mailed, how it was received, where it went after that, how long it was stored before it was ran.
It seems to me, and I'm not trying to interrupt you, that this is something that should have been looked into way before this.
And see,
And I've seen nothing.
I don't, and so you can understand when I get to cases, the only way I get facts, like true facts and all of the information, which is called the discovery and those things, is through a trial or through other hearings that could possibly come into play. And we haven't had a trial, so I don't have any of the information that you're talking about. I just know the basic facts of the allegations that occurred on December 3rd, 2023, which goes into the start of when you were first picked up, what happened with the blood draw and the transport, again, at least through the officer's perspective, which is probably a combined total of 2.25 pages of a narrative. Those are the facts that I get from the case, other than what's argued to me from both sides, and what's argued or I don't want to say argued, but told to me by the defendant. Okay. And so my job here is to make sure that I understand you're accepting the plea, and you're essentially saying, I'm backed in a corner. I want to get this done. I don't have the funds to fight this. But I need to make sure that you understand that, at least from my perspective, where I'm coming from, I have the narrative from the law enforcement officers, the arguments from the counsel, and again, the science in a report that I don't even think I get the report. I don't think the report is even here unless I'm told. And usually I would say, okay, either Mr. Renicky or Mr. Chapman, what was the BAC? What was the blood alcohol content that night? What does the report state? That's the basic of the information that I get when I proceed in a case where I do a plea and sentencing. And so I hear where you're coming from. And it does sound like it's a big deal. And especially a big deal to you and to your reputation and to your character. But I have to make sure that you understand the ramifications of accepting a deal instead of moving forward to trial.
Well, as we know, like I said, I think we're all in agreement. It's not what you know, it's what you can prove. If I were to go to trial with a jury of 12, I might get lucky and get enough of them that I've served in the bar. Maybe not. Might be lucky enough to get enough of them where they just give me the not guilty no matter what. Who knows? Fact of the matter is that the one thing that I actually needed to not be sitting here right this second was that new camera film, which I cannot get. I do not have. And without that camera film, I have 2 witnesses. Whether they're going to take the credibility of those 2 witnesses, one of the witnesses, perhaps with her own current situation, that's not going to come across as credible. And actually, in a weird...
I don't know who you're talking about.
Well,
Could she?
doesn't matter. The other witness also, you do know as well, you're dealing with something on that person. And the credibility of those 2 witnesses, because of those 2 situations of their own creation, I lose my credibility on banking on those two. So without the film, I'm Scrooged. I just wanted to, can I say Scrooged?
Yeah.
I just wanted to clear on record that I'm not just laying down here because I know for a fact what I did drink, regardless of what lippy stuff I said to an officer with a body cam.
Okay.
They know what I drank because they served me. I just don't have a film to be able to prove it from 10 a.m. when I opened the bar to the 9:30-ish when I left it. And does this affect me? Absolutely. I'm looking at a third offense with a fourth offense. Well, I don't drink, so it doesn't matter to me anymore, but with a fourth offense, that's a huge problem. I'm looking at a loss of my license, which is a huge problem.
She knows the penalties for an OW.
Yes, I'm very well aware.
Okay. And so you've had time to think about this. And so I'll do is I will set this aside to another date. If you're telling me you want to accept the plea, then we'll move forward that way. Otherwise, we can set it for a trial.
Judge, are you going to accept an Alford plea on this?
Yes.
Okay.
It sounds like Mr. Davis has a lot that he contests, and he understands that in his situation that there would be enough here to prove guilt beyond a reasonable doubt because of the lack of the evidence that he believes he has. Therefore, do you understand what an Alford plea is?
Absolutely. It means I'm not pleading guilty or unguilty or anything, but basically I'm still guilty.
I don't accept those often, Mr. Davis, but with your statement here today and the information you've provided to the court and how, I want to say, adamant you are on the night and how it occurred, I think an Alford plea, Mr. Chapman, would be acceptable. Unless the state were to object or to wish to provide any argument as to why the court should not.
I have no objection either to a no contest plea or an Alford plea, or a trial.
All right. So we can move forward and you can talk to your attorney further about that Alford plea and if you wish to accept it. Mr. Chapman, I believe I have you coming back. Are you coming back in person on September 18th for that status with Ms. Shannon? Yeah, you can't work. Yes, Mr. Davis?
Let me choose my words wisely here.
Yes, I was going to be there in person.
October 18th to the 21st, I have to be out of state.
Well, September 18th.
Well, what I'm saying is that September 18th
Oh,
is
he'll be in jail or.
I'll be on
house
home
arrest.
monitor system because I've given her the money and the checks for this.
Well, monitor for what?
If he's convicted on September 18th, he will be in house arrest for when he's supposed to be out of
Yes.
state in October.
And where are you going out of state?
I will be in Toledo, Ohio for a 3-day business convention from the 17th to the, well, we'd be back the 20th, that Sunday night sometime.
Well, oh,
I have a very complicated life. I'm not just a bartender. I also do merchant to merchant credit card services, and I'm building a business that requires me to travel.
and you wouldn't be drinking?
I don't drink. My point is this, is that I as much as it's,
Can we just do it after the October, after he gets back in October?
Yes, we could do that. So when do you get back in October?
October 20th.
Oh, that's a long trip.
Well, it's the 17th. We will
17th,
leave on
20th.
Thursday.
It's a weekend.
The convention starts on Friday. It's
I
full
was
day
thinking,
Saturday and
yeah.
Sunday.
But
Yes.
it's late, and so he'll still be sitting some time arguably, if he's,
He will still be on house arrest at that point, even with the IDIP.
Which most likely will not allow me to leave the state.
I make the rules, so yeah, you can actually leave the state. But I
Well,
would need a whole lot more information about that trip to be able to approve it.
the inherent problem there is, according to Miss Tessa, and this is gonna be a rule, even on house arrest, if I were to start this thing today and just be done with this, it's complicated because like I have to be in Rochester every month on the third week. I'm sorry, Ren, what day is that in Rochester? Saturday.
Well, again, as long as there's a lot of information that's provided to the court, things like that can be approved. It's just not, you can't go to fun things. You can't go to graduation parties and birthday parties and all of those fun kind of things.
Well, you may
because
find it hard to believe, but I don't have a lot of friends, so I don't have to worry about
it's
that.
supposed to be house arrest, but Huber, work-related things is okay. October 24th at 11:30.
I have 3 hearings in St. Croix County at 9:30. I'm probably not going to be able to get here in time.
At 2.
That would be fine.
So October 20, well, that's, oh, sorry, that's on a Schmidt week. I could do October 31st.
Jury trial judge.
Bad luck.
Yeah. So is it okay if we do it on a Schmidt week?
Yeah, that'd be fine.
It's,
All right.
it's an IDIP recommendation, so
October 24th at 2. Anything further?
not for me, Judge.
All right, thank you. And if there is something like that that you say is within the normal course of your business that you have to travel, but it's work related and you would be on the monitor, just come prepared, have that written down of all of those things so I can review it, so I can pre-approve it to tell Ms. Anderson, I'm approving this, I'm not approving it or doing those things, okay?
Yes.
All right. Thank you. We are adjourned.
Judge,